for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor Hello, can I have your name, please?
My name is Daniel Mcu.
Okay, just a moment. Take a look at that. You may need to decipher my notes. Okay. Okay, you said your last name is pronounced Magoo?
Yes, ma'am.
And generally speaking, I appoint the public defender's office to represent at least at the arraignment stage, but I was informed that you didn't want to speak with the public defender, so are you intending to represent yourself for the arraignment?
I'm here to figure out what the charges are. What am I being charged with?
Now calling case number 25S00289. This is the State of Michigan versus Daniel Ryan Magoo. Can you please state your name for the record?
I'm trying to figure out what the charge is.
Yes, that is the purpose of the hearing today. So, as
Who's
part of
the complaining victim?
as part of the proceedings, can I have you please state your name for the record?
My name is Daniel Mcu,
Okay.
and I am
thank
not
you.
a surety of the state. I'm not a ward of the state.
Okay.
Can I ask what the charges are?
Yes, I am getting there. Please give me a moment. So, what we are here for today is an arraignment. The purpose of an arraignment is to inform you what you are being charged with and to make sure that you understand the charges. I am not going to be asking if you agree with the charges. I am not even going to be asking if you understand why you are being charged with them. The purpose is to make sure that you understand what the charges mean and that you understand what the potential maximum penalties are. So, what I have here is a misdemeanor complaint that charges that on or about or between the dates of February 15th, 2025 and June 23rd, 2025 at 6988 McKean, Lot 72. You did maliciously use a service provided by a telecommunications service provider with the intent to terrorize, frighten, intimidate, threaten, harass, molest, annoy, or disturb the peace and quiet of Alyssa McCloskey, an individual with whom you have a child in common, by using any vulgar, indecent, obscene, or offensive language, or suggesting any lewd or lascivious act in the course of a conversation or message through the use of a telecommunications service or device. This is otherwise known as malicious use of a telecommunications service. Do you understand what the charge means?
I do not understand that. I do not understand malicious use
Let
of a
me
telephone
rephrase.
service.
Do you comprehend that what I am saying is that you allegedly maliciously used a telecommunications service device that would generally be a cell phone? I suppose it could also be a computer or something else
No, that
you
didn't
could use.
happen.
Okay. And again,
February,
as I
what were the
stated,
dates? What dates?
between February 15th and June 23rd
Of this
of
year?
this year. Yes. Okay. Now, as I stated at the beginning, I'm not asking you if you agree with the charge. I'm not asking you if you understand why you're being charged with them. What I want to know, basically, is do you know what the words coming out of my mouth mean? The way that this is going to work is this. If I am not able to arraign you on the charges because I can't tell if you understand what I am saying, then the next thing that happens is that you get referred for a competency evaluation. At this point, I do not know how long that will take, and that means that you will stay where you are until we are able to either arraign you or you are determined to be incompetent.
So I don't have, I'm not like I said before, I'm not a surety. I'm not a ward. I'm actually a protected individual, and I did no crime. There has been no body of a crime, no corpus delecti. I have committed no crime at all.
Mr. Magoo. If I cannot determine whether or not you can understand what you're being charged with, then I cannot arraign you.
Okay.
So,
If there is not a body of a crime, if I have not harmed anybody, then you can't arraign me. It's corpus delecti. It can't happen. If you do try to enter in a plea of competency, or I don't know what is that? What you're gonna hold me here hostage until what? A body of a crime happens? When is the crime gonna happen?
okay. So, Mr. Magoo, we will not be proceeding today with the arraignment. You are free to go to the door until the jail that you are finished. Thank you.
Grant a personal reconnaissance on my behalf. And for both of these charges, being that we're looking at really just misdemeanors, $500 misdemeanors. So
I think he's requesting, Your Honor, amend his bond, and he's requesting a release, Your Honor, PR bond.
And a response from the people regarding his bond.
The people would ask the bond be continued, and he also failed to appear before Judge Lane.
Yes.
But also with respect to the other comments. I'll wait. If there are pleadings filed by the defender's office, our office will respond to that. And I guess my one remaining point would be, with the court's appointment Eastern the Public Defender's Office, I will make sure that the initial discovery that I referenced is certified by the Defender's Office.
Yes.
Thank you, Judge. We will review that with our client once we receive it.
So he's asked for a preliminary examination, and I realize where this may be. My understanding is that he is still being held, regardless of what the bond would, in this case, he's being held without bond in Judge Slay's case.
That's my understanding.
That his bond has been denied, so
That's what
I would
Mr. Choda said.
in any event, But also given the fact that one of the charges is the escape from lawful custody, that in and of itself, in this court's mind, makes the defendant a danger for a risk of flight. Also, the nature of the charges, the fleeing and eluding police officers, as well as the operating while intoxicated, now at least alleged his third time around. Also, this court's mind, the defendant, this court would consider a danger to the public. So the extent that he is asking that I modify his bond conditions in this his bond in this case,
I have,
that motion is denied. Bond will continue as it is.
Your Honor, I have a 14th Amendment due process to the presumption of innocence. And
I understand the presumption of innocence.
a lot of these are facially invalid, Your Honor.
Excuse me?
A lot of these charges, especially the lawful custody, escape from lawful custody, it's facially invalid. I was at a hospital, not a jail.
If you were under the custody of the Washtenaw County Sheriff's
I was
Office,
not.
I understand.
I was not.
Custody of.
I was dropped off at the hospital and they later tacked on charges just like the fleeing and eluding charge.
Not beat that out. And that if that's true, and the people can't sustain that element, then the charge will be dismissed. But I'm not dismissing it upon your representation today.
Thank you very much, Judge.
Preliminary examination in this matter will be set August 19th, 2025, 12 noon. That is before me on that date for both of these cases. I will apprise the parties also that one of the, I will call it one of the activities, and I think it is a maneuver to have the court do something that it normally would not do. The defendant has elected, and I will disclose it, to file a civil claim as against me and a slew of other parties.
Oh yeah, in that regard, Your Honor,
Many of those, do not interrupt me.
Well,
including many that I don't even know the connection. Court has, this judge, upon receiving this, two things. I read through the complaint to determine whether or not it would on its face create a conflict with court. I consider it, quite frankly, to be frivolous. Complaint itself, do not see that as a necessity for me to recuse myself from this gentleman's proceedings, because I think that's precisely what he wants to have happen, and that he's attempting to manipulate the system. He will be dealt with by me as I deal with any other defendant, and so that is there. It has been turned over to the Office of General Counsel for the Washtenaw County. They will deal with, for me, and as well as the others that I see that are listed there, they will deal with that. They have also filed, it appears, and again, this is all part of his, what I will call shenanigans to shape this. He has filed against people, individuals without specific reference in the Washtenaw County Prosecutor's Office. I don't, as I view what I read, would not consider that any jeopardy upon their objectivity in handling this case. So,
yeah.
You've been aware of such filings were being received by our office maybe yesterday. At this point, we continue to proceed with this case until I did otherwise from the elected prosecutor.
Can I speak on that note, Your Honor?
I will let you talk, but I'm not going to let you go on in some diatribe. I've got other things to do.
I've stood on my rights and I've stood on my beliefs this whole entire time, especially in the previous case, Your Honor. That complaint is well pleaded. It does affect multiple parties of this jurisdiction. Washtenaw County is a named party, and I do believe that my impartiality and bias will be affected here, as it was in the past before this complaint. And I do request a change of venue on that note for both these matters.
If you wish to raise change of venue, you may file that in writing, but to the extent you are raising no motion for change of venue, denied.
Thank you very much, Judge.
Bond will continue. Thank you.
Somebody be able to continue.
Examination, I would
I
expect.
would set it for the 19th and then
Well,
he'd have them well in advance, and I'll do it that way. Prior to setting the preliminary examination, it's being a critical process, a couple of things that the court wants to do. Mr. Magoo, starting in case ending in 0979. Mr. Magoo, you are before the court on a felony complaint that alleges 4 different counts, or 5 different counts, excuse me, including and eluding 4th degree, which is a felony punishable by up to 2 incarceration, $2,000 fine plus court costs. Count 2 is operating an unregistered vehicle, which is a misdemeanor, punishable by up to 90 days. Operating without security, which is a misdemeanor, punishable with not more than 1 year or less than a $200, nor more than $500 fine plus court costs. Count 4, operating with license suspended, denied, and or revoked. That is a misdemeanor, punishable by up to 93 days. $500 fine plus court costs, and your vehicle would be subject to mobilization. Count 5 is refusal to obey a lawful traffic order of a police officer. That's a misdemeanor, punishable by up to 90 days, $100 fine plus court costs. Those events are alleged to have occurred on July 3rd, 2025, I-94 near Parker Road in Scioto Township. That is on the one case. On the other case, which is a 3-count complaint, that 3-count complaint alleges that on March 27, 2024, location of Dexter near Arcona in the city of Milan, Washtenaw County, state of Michigan, that you did operate a motor vehicle while intoxicated. That's a misdemeanor, punishable by up to 93 days, $500 fine plus court costs. There is, however, a third offense notice, which transforms this into a felony charge. It's punishable by up to $500 to $5,000 fine plus court costs, 1 to 5 years in jail, probation with 30 days or 1 year in jail, or at least 48 hours to be served consecutively, and 60 to 180 days community service, any rehabilitative programs the court deems necessary. Court could order you to pay the cost of the prosecution and the cost of any emergency governmental services, and your vehicle would be subject to mobilization. Count 2 is operating while your driver's license was suspended, denied, and or revoked. That's a misdemeanor, punishable by up to 93 days in jail, $500 fine plus court costs. Count 3 is lawful escape from custody, or escape from lawful custody, excuse me. That's a misdemeanor, punishable by up to 1 year, $1,000 fine plus court costs. Mr. Magoo, I would just ask, do you still wish on representing yourself, sir?
Your Honor, I will. I have requested assistance, given that I am incarcerated and I have no way to.
Do you wish to be represented by an attorney, sir?
I would like legal assistance.
What do you mean by that? Would you like to be
Well,
represented by?
I've called the
Well, Mr.
prosecutor.
Magoo, we go through this every time. So here's what I'm going to do. I'm going to advise you that there are great perils in representing oneself. I've told you about that before on numerous occasions. That I would treat you the same as I would treat anybody else. You would have to know the Michigan court rules. You'd have to know courtroom procedure, and that you would be treated the same, not any more favorably, not any worse, as you would go through these proceedings. If you wish to represent yourself, you may proceed with the court's admonishment. I advise you as to the penalty, the charges, the maximum penalties. I will now ask you the question, and I'm not going to just keep going around and around in circles when I ask you this question. Do you wish to be represented by counsel? If you wish to be represented by counsel, this court will ensure that counsel is appointed to represent you.
If
That is a yes or no.
I would like legal assistance, yes, Your Honor.
I'm going to take that as your request for counsel, is how I'm going to take that. And so these two cases now become public defender cases.
Thank you, Judge Torsia Feaster, Assistant Public Defender on behalf of the defendant. I believe Your Honor has already agreed to set it for examination.
He's asked for examination in the case, and so I will set these for preliminary examination.
Well, Your Honor, I would ask, given that one of these cases, in regards to the March 27, 2024 case, there is an undue delay. It's been over, I think, 390 some days since the warrant was requested, and this triggers due process violations under U.S. versus Levasco, People versus Bassard, People versus Rosengreen, and procedural unfairness, Sixth Amendment violations, and I do request that the prosecutor provide provide information in regards to the three-pronged test under People versus Hernandez. One of them, first test being the explanation for the undue delay for 390 some days. The second part of that test being to prove that the delay was not deliberate. And then the third part of the delay or the prong test is to make sure that there was no undue burden on or prejudice on the defendant. And in that regards, Your Honor, I also am requesting that I do have due process 14th Amendment rights as well as 8th Amendment rights. And a lot of these are facially invalid. A lot of these charges are facially invalid. And I'm just requesting that the court.
Let's break down exactly what just happened here. This was an arraignment, not a trial, not a constitutional debate, not a First Amendment hearing. The judge's only job at this stage was to inform Daniel of the misdemeanor charge: malicious use of a telecommunications service, allegedly sending harassing or threatening communications to Alyssa McCloskey, someone he shares a child with. She clearly explained the elements, the time frame, February 15th to June 23rd, 2025, and the purpose of the proceeding. But instead of confirming he understood the meaning of the charge, Daniel pivoted to arguments about constitutionality, corpus delecti, and whether there was a body of a crime. Here's the key legal point. At arraignment, the court does not need to prove guilt. The judge is simply ensuring the defendant comprehends the accusation and potential penalties. When he repeatedly said he did not understand, even after clarification, that triggered a major issue: competency. And that's where this became serious. If a court cannot determine whether a defendant understands the proceedings, the law requires a competency evaluation. That can mean delays, custody holds, and significant procedural consequences. Ironically, by refusing to acknowledge understanding, he risked prolonging the situation far more than simply entering a plea and challenging the charge later. So here's the big question for you. Was this a strategic move, or did it backfire completely? Should he have saved his constitutional arguments for a motion to dismiss instead of fighting the arraignment itself? At the end of the day, the judge made the correct procedural call. She cannot proceed without confirming comprehension. No arraignment, no plea, no forward movement. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.